Welcome to the next installment of in our series on handling a criminal case. Today we're going to talk about plea bargaining. Plea bargaining is something that most people have heard about, a lot of people have opinions about it, and most people don't have any earthly idea what actually happens. The fact is, most criminal cases, somewhere in excess of 90%, are resolved through plea bargaining. So you need to know what it is and how it works. Plea bargaining really is nothing more than an agreement between you and the state. They agree to offer you a specific sentence or a specific disposition of your case. You agree that in return for that agreement, you'll give up the right to have a trial, whether it be a jury trial or a trial to the judge, and that you'll enter a plea of guilty. You get the benefit of knowing what's going to happen in your case and having certainty. They get the benefit of not having to go through a trial, and they also get certainty so that they know what happens. There's a difference, and usually a pretty significant one, as to how cases are handled in the negotiation process between felony cases and misdemeanor cases. In most counties, for most misdemeanor cases, there are generally standard offers. For example, a DWI case, a standard offer might be 180 days probated for 18 months and some amount of fine. In felony cases, it's different, at least in most places. And depending on the offense, there's a lot more flexibility in felony cases. There usually aren't set offers, although there are general ranges, especially for the more minor offenses like possession of small amounts of drugs. There's a couple of factors that go into determining what the plea offer is going to be in any particular case. One factor is obviously the case and the facts of the case, and the other is your situation and your history or lack of history. The facts are important because sometimes there are aggravating facts, for instance, a DWI with an accident where somebody may have been injured or there was some property damage, or it may be something minor. Your situation is important because they're going to treat someone differently who's a first-time offender as opposed to somebody who's been through the system before and maybe has been on probation before or maybe even been to jail or prison. So how do you go about determining what an offer is going to be made? Generally, the state is going to come up with what they think an offer is, or a reasonable offer should be in a particular case, and that's going to be based primarily on those two things I mentioned, the facts of the case and your history. That's going to come from the offense reports. They're really going to do nothing more than review the offense reports, review whatever they have available, review your criminal history, and make a determination. They're not going to generally do any kind of independent investigation or evaluation. You have to remember they have hundreds of cases to go through, and they're reviewing what's before them, making decisions. It's up to us or your lawyer to point out to them why your case may be different. It may be something with the facts. It may be some problem they have, maybe proving what you did or maybe proving that you did something as serious as they claim. It may be a problem with the law. Maybe there's some question about a stop. Anything that's different about your case is something that's going to be important to point out and for them to know. Your situation can be important too. Again, that's something that we have to point out. You may have had, or you may have a bad criminal history, but it may be something that was in the past. We've seen people that picked up several DWIs when they were in college, and they may now be in their 50s or 60s and pick up something else. There's a big difference between that person and somebody who's got a history of getting one DWI right after another. Plea bargaining is like most other negotiations because that's what it is. The state's going to make an offer. We're going to make a counter offer, and usually we're going to come to some somewhere in the middle, or some resolution. Once the plea offer is made, then it's going to be reduced to writing, and there different documents will be prepared that you'll need to sign when you go to court, because you're going to have to go to court, and that agreement is going to have to be presented to the judge. Most times there's not a problem because judges are confident and they have faith in the prosecutors that they're going to reach a reasonable agreement. But just because you have an agreement with the state and everybody else agrees, that doesn't mean that the judge has to go along with it. The plea bargain must still be accepted by the judge. He has the right to either accept it or reject it. There are some situations where a court may think that a plea offer is too lenient, or they may think that there's some factor that's not proper, and they don't accept it. So you wonder what happens in that case. Fortunately, you're not stuck with whatever the judge decides to do to you. When you enter a guilty plea, that plea is conditioned on the judge accepting it. If the judge doesn't accept it, then you're allowed to withdraw your plea, and basically you go back to the drawing board and start over, and either come up with an agreement that the judge is going to approve, or you may end up going to trial. The other question most people have is, when do you start this process? For prosecutors, they start it pretty early. When they get the file, they get an idea of what the case is about and what they're going to offer. For us, we take a little bit different approach. You can't really know what a reasonable offer in a case is until you know all the facts. We may know what the police say, we may know what the reports say, but we don't know what you say, and we don't know what any independent investigation says. So we're usually not going to start negotiating a case and entering into any kind of plea agreement until we know what all the facts are, and we can then make a decision on what we want to do. Plea bargaining is something that's a personal right for you. It's one of those things that is a right that you have, and you alone. We can advise you, we can tell you whether we think it's a good deal, whether it's a bad deal, or somewhere in between. The decision on whether or not you take it is up to you. Nobody can force you to do that. You have to make that decision on your own. So hopefully this gives you some insight into the plea bargaining process. As always, if you have any questions about anything, if you have any questions about how this may work in your particular case, please reach out and give us a call or get in touch with us.